All right, I'm actually back. I ended the last video sort of quick and felt the need to actually come back to make some additional points. So I am actually going to continue on from where I left off in that same period. Uh, so in July 1640, you actually have this case, and this is not by statute, but it's by case law. And it's a case concerning three runaway servants from Virginia to Maryland. And so this reads, whereas Hugh Gwynn hath by order from this board brought back from Maryland three servants formerly run away from the said Gwynn, the court doth therefore order that the said three servants shall receive the punishment of whipping and to have 30 stripes apiece, one called Victor, a Dutchman, the other a Scotchman called James Gregory, shall first serve out their times with their master according to their indentures, and 1 whole year apiece after the time of their service is expired, by their said indentures in recompense of his loss sustained by their absence, and after that service to their said master is expired, to serve the colony for 3 whole years apiece, and that the third, being a Negro named John Punch, shall serve his said master or his assigns for the time of his life. Let me hide this. For the time of his natural life here or elsewhere. So you have, in the case of these three servants running away, you can clearly see that because John is Black, John receives a life sentence of inservitude. This is noted to be the first legalized case of racial slavery that commences in the colonies. I believe it's Massachusetts, actually, that is the first colony to declare the institution of slavery legal, and that happens the year after this. But through the courts, by case law, this is noted to be the first case. Some additional laws that you see during this period, in terms of the sumptuary laws that I mentioned, in the declaration or the declaring of the colonies being Christian nations, if you will, you have the Maryland Toleration Act, or a law of Maryland concerning religion, rather. And this law says in it, and this is one of the earliest laws that actually shape the religious context of the colonies, in the onset of Christianity in America, as we know it. This law says, forasmuch as in a well-governed and Christian commonwealth, matters concerning religion and the honor of God ought to be, in the first place, to be taken into serious consideration and endeavored to be settled, be it therefore ordained and enacted by the Right Honorable Caecilius Lord Baron of Baltimore, absolute Lord and Proprietary of this province, with the advice and consent of the upper and lower house of this General Assembly, that whatsoever person or persons within this province and the islands thereunto belonging shall henceforth blaspheme God, that is, curse him, or shall deny our Savior Jesus Christ to be the Son of God, or shall deny the Holy Trinity, the Father, Son, and the Holy Ghost, or the Godhead of any of the said three persons of the Trinity, or the unity of the Godhead, or shall use or utter any reproachful speeches, words, or language concerning the Holy Trinity, or any of the said three persons thereof, shall be punished with death and confiscation or forfeiture of all his or her lands and goods to the Lord Proprietary and his heirs. So within this first one of the first or the first law that is concerning religion and taking it head on. You see, it is being instituted in the form of a cult. It is forceful, it is violent. If anyone resists the cultural context that is developing and or being applied, they will be murdered. And the assets that they once or may have owned, that could potentially pass on to their family members, um, that will be forfeited. It will be taken away. So, what then is Christianity, right? That's an entirely different conversation. But the main point of me sharing this is that this represents um, white American legality and really the formation and shaping of institutions in America. This is concerning religion. I'm going to move on. You've got runaway laws that are instituted that um, really are instituted to prevent Black people from resisting white cultural terror that is being thrust upon Black people in the forms of flogging, of murder, which I'm going to get into in just a moment, rape, which I'm not going to cover that today, but I will get into it in a later segment. But so you've got this law that says, and in case any English servant shall run away in company of any Negroes who are incapable of making satisfaction by addition of a time, it is enacted that the English so running away in the company with them shall at the time of service to their own masters expired, serve the masters of the said Negroes for their absence so long as they should have done by this act, if they had not been slaves. Every Christian in company serving his proportion, and if the Negroes be lost or die in such time of their being run away, the Christian servants in company with them shall by proportion among them either pay 4,500 pounds of tobacco and cask, or 4 years' service for every Negro so lost or dead. So this law, in essence, is basically sending a message to white people that you should not be running away with Black people. You should not be standing in solidarity with them. Christian here represents an ethno-religious context. It's aimed at non-English, European, Anglo people who are represented in that context at the time. So you've got Scots-Irish people, Dutch people, Portuguese people who might be contained and or represented with that label. Represents an ethno-religious identity at this particular juncture, right? And so here's what would happen if Black people resisted white cultural terror that was happening to them. And this is what I cover in my book, right? And so we're not just trading in human lives and or kidnapping and stealing Black people from certain regions within Africa. We are forcing them into a landscape and we are forcing them into a situation of forced imprisonment into slave labor camps, forced involuntary confined slave labor camps that we refer to many times, as plantations. But these are internment camps, right? These are prisons. They are owned by individuals, and later there's the development of the jail system or incarceration or prison industrial complex, which is more of a communal ownership. But you have within the creation of these laws the shaping of a system of pro-white affirmative action, that any and all actions white people want to take and or enact as it pertains in relationship to Black people, in relationship to African Americans and or Negroes, they can enact those actions at any given moment, including the most severe acts of violence and terror, right? And so you've got this law in 1664 that declares that Black men are slaves, or so going to be, if you are Black and male, you are enslaved. And also, if you're a white woman and you engage in a relationship and or marry a Black male, then you are to be enslaved as well. So this is an act of 1664. This is Maryland. And this act says, be it enacted by the right honorable the Lord Proprietary, by the advice and consent of the upper and lower house of this present General Assembly, that all Negroes or other slaves already within the province, and all Negroes and other slaves to be hereafter imported into the province, shall serve durante vita, hard labor for life. It goes on to say, and all children born of any Negro or other slave shall be slaves as their fathers were for the term of their lives. And for as much as diverse English women, forgetful of their free condition, and to the disgrace of our nation, marry Negro slaves, by which also diverse suits may arise touching the issue of such women, and a great damage befalls the master of such Negroes, for prevention whereof, for deterring such freeborn women from such shameful matches, be it further enacted by the authority, advice, and consent aforesaid, that whatsoever freeborn women shall marry any slave from and after the last day of this present assembly shall serve the master of such slave during the life of her husband. And so you can see here, if you look at the psychology behind these laws, there are definitely strong anti-Black motivations, right? And it's an anti-Black psychology. And you can really parse through the language here and see that words like disgrace and a great damage befalls the master, shameful matches for prevention of which, for deterring such freeborn women from such shameful matches. It's the laws are being built. The legal system, the white legal system, is being shaped and or invented, if you will, with a underlying affect of anti-Blackness that is extremely severe and strong, right? This law goes on to say, and that all the issue, all of the children of such freeborn women, of such white women, so married, shall be slaves as their fathers were. And be it further enacted that all the issues of English or other freeborn women that have already married Negroes shall serve the masters of their parents till they be 30 years of age and no longer, right? So Theodore Allen, one of the points that he deals with in his book, The Invention of the White Race, he says that these people were not necessarily the people who from Europe, these Anglo-Europeans who were of different ethnicities, some as it is noted in the historical record, mainly English, but again, also Scots-Irish people who were represented, Portuguese, Dutch, and even some Jewish people, even that were present in the colonies during the 16th and 17th centuries. He says that white identity had to be carefully taught, and it would be another 60 years before the word white would appear as a synonym for European American. And he's talking about the period between 1619, when the first Black people appear in the colonies, as we know, and as is really represented and emphasized throughout Nicole Hannah-Jones's 1619 project. And he's referring to this law of 1681, where it's a law that is concerning marriage between white and Black people. And the English began to create such laws, infusing the language of not just identifying themselves as a race and or ethnic group, but white women. So they are combining all of the people represented within those European ethnicities into this term. And later on, they begin to include themselves. And it just becomes white people, right? So, for as much as diverse freeborn English or white women, sometimes by the instigation, procurement, or connivance of their masters, mistresses, or dames, and always to the satisfaction of their lascivious and lustful desires, and to the disgrace not only of the English, but also of many other Christian nations, do intermarry with Negroes and slaves, by which diverse inconveniences, controversies, and suits may arise touching the issue or children of such freeborn women aforesaid, for prevention whereof for the future be it enacted that if the marriage of such women servant with the slave shall take place by the procurement or permission of the master, such woman and her issue shall be free. Because they were enacting this law, I'll just say it really quickly, to um, prevent, to deter these masters and people who were encouraging marriages between white and Black people to ensure that they could have more property by enslaving white women. They erected this law for that case, but then they reneged on it and created other laws that just imprisoned people who married Black people. But you see, he says white people had to be taught what it meant to be white. And they had to be taught what it meant to be white in relationship to Black people. So you have laws like the Casual Killing Act of 1669 that say, whereas the only law in force for the punishment of refractory servants resisting their master, mistress, or overseer cannot be inflicted upon Negroes, nor the obstinacy, the stubbornness of many of them be suppressed by other than violent means, be it enacted and declared by this grand assembly, if any slave resist his master or other by his master's order, correcting him, and by the extremity of the correction should happen to die, that his death shall not be accounted a felony, but the master or that other person appointed by the master to punish him be acquitted from molestation, since it cannot be presumed that premeditated malice, which alone makes murder a felony, should induce any man to destroy his own estate. So what this law essentially says, it says a lot, but what it essentially says and does is that no white person would kill their Negro slave that they own on purpose. They would not destroy their property on purpose. So if in the case of chastisement, if they happen to be chastising them and they go overboard because they get a little too angry and they just happen to kill the Black person, or if they have appointed another Black person, another slave, to chastise the slave, and that person has, let's say, some resentment for that person, they get a little bit angry and go overboard, and they kill that person. If they kill a Black person, that there will be total absolution. One of the things that Dr. Joy DeGruy notes in her book, Post-Traumatic Slave Syndrome, in her work, is that this law was erected to protect white women who were disciplining Black children, and the children were starting to die. And so to absolve white women and also white men and anyone that they appointed from the moral accountability and any legal accountability that by English law they would be held accountable per se. This law was enacted, right? But what my work is concerned with, and what I am concerned with, is when you follow the through line of such laws like this beginning in 1669, and then you go through the 1700s, and you go through the 1800s into the 1900s, where you've got the Supreme Court really ruling that Black people, this is 1883, 1876 and in 1883, the Supreme Court rules twice that Black people can't be protected from cultural terror. And then you've got like mass lynchings that take place, right? What builds in the psychology, not only of white people, but what builds in the psychology of any and everyone who are participants and or constituents or representatives or people who exist in a cultural context that has been trained or that has been built upon the idea of terrorizing Black people and kind of the normality around that, the normalcy of it all, right? You've got, and I'll give you just a few more examples. This law in 1680 preventing Negro insurrections, because again, if you were being raped or you saw your child raped or your parents raped, or if you were being murdered or you saw your mother murdered or your grandfather or cousins being murdered by people who consider themselves moral, Christian, upstanding people, you probably fight back too, right? So as Black people are getting together to resist, they implement more laws. And so this law of 1680 says, and some of you who follow my work may have seen this before, whereas the frequent meeting of considerable numbers of Negro slaves under pretense of feasts and burials is judged of dangerous consequence, for prevention whereof for the future, be it enacted by the King's most excellent majesty by and with the consent of the General Assembly, and it is hereby enacted by the authority aforesaid, that from and after the publication of this law, it shall not be lawful for any Negro or other slave to carry or arm himself with any club, staff, gun, sword, or any other weapon of defense or offense, nor to go or depart from his master's ground without a certificate from his master, mistress, or overseer, and such permission not to be granted but upon particular and necessary occasions. Total regulation of where Black people should be, where white people can determine Black people should be at any given time. We must be able to prove that, and or if it's sanctioned in the minds of such people that these Negroes or Black people shouldn't be in a particular space at any given time, then they can harass them, right? They have to show proof. So, how does that still show up today? The next portion of this law says, and every Negro or slave so offending, not having a certificate as aforesaid, shall be sent to the next constable, who is hereby enjoined and required to give the said Negro 20 lashes on his bare back, well laid on, and so sent home to his said master, mistress, or overseer. And it is further enacted. You know what? Let me stop there. Okay. So now, right, in this portion of this law, it's basically saying that if a person, if a Black person is not able to prove that they should be in any particular space at any given time, they don't have that certificate. The cops are going to be called, and they are going to be required to put that Black person in their place. They're going to be required to give them 20 lashes on their bare back, right? So how does that show up now when Black people are suspected to be in the wrong place or the wrong time, whether it be trying to get into their house, skip gates, or trying to go for a jog, Ahmaud Arbery, or trying to drive when you're coming from an interview at a college, Sandra Bland, right? How does that happen today and or right now, right? Or the cops having a no-knock warrant, Amir Locke, in the case of Amir Locke, and going to the wrong apartment. The same with Breonna Taylor, right? Now, though, the little girl that was selling water on the street, right? It's determined she shouldn't be there selling the water. The cops are called, and now Black people end up dead. Police just shoot. So again, there's no difference between the cultural foundation and affects that are being shaped through these laws that are erected, that manifest during this period, and then they are reinforced throughout the formation of the United States. Laws that are established at the congressional conference, and then laws that emerge in each state that sanction that Black people can't testify against white people, and the Supreme Court decisions that I mentioned a moment ago that rule against the 14th Amendment protecting Black people's rights to protections of cultural white terror that emerges during the late 19th century into the early mid 20th century. This law goes on to say, and it is further enacted by the authority aforesaid, that if any Negro or other slave shall presume or lift up his hand in opposition against any Christian, shall for every such offense, upon due proof made thereof by the oath of the party before a magistrate, have and receive 30 lashes on his bare back, well laid on. So if a white person says that a Black person meant them harm in any way, if they lift up their hands to defend themselves in this era, at this particular juncture, they might defend themselves if someone is coming after them to murder them, or just trying to give them 30 lashes on their back. I think I would fight back. I think I would want to defend my brother if I saw that happening to him. I think I would want to defend my mother if I saw her being raped, right? So it's not really logical that this is happening, that we're going to sanction terror is normal against these people, and then we're going to expect them to not react. But in order to protect our ideological and legal psychosis, if you will, we're going to enact laws that actually make us right in terms of the legal and the moral context and or implications of all of this. So again, how does this show up today with the policing of Black bodies? And it's not just white people. It's Asian people, it's Hispanic, Latinx people, and even some Black people who are concerned and or preoccupied with suspecting Black people and or degrading Black people, not treating Black people with as much dignity or respect. And so in my work, I talk about this as a built-in psychology of anti-Blackness. It's not just implicit bias. It's not just a social construct. You've got these two little girls here, Faith Finity on the right. I cannot emphasize this enough. Her mother does her hair in a hairstyle that is very beautiful. She looks amazing. And the school implements a hair policy that says essentially that her hairstyle is out of compliance with the standards of the school. Okay. Marion Scott here on the, and I want to say this, she gets suspended for 3 days. She gets suspended for 3 days because by white American standards of policing Black people, skin color, skin tone, way of dress, way of speaking, everything, and hair in this instance, she's not appropriate. She's not showing up, and she doesn't belong. That hairstyle that her mother chose to give to her doesn't belong. On the left here, you've got Marion Scott, 8-year-old young girl. She is excluded from her school picture because of the way that her parents decide that her hair should be. It's just not appropriate. It's not seen as beautiful or pretty or anything affirming. It's seen as negative and or distracting, and so on and so forth. You've got these 4 12-year-old girls who were suspected of being too giddy, laughing too much. They were laughing, I believe, in the school cafeteria or maybe in class, and they're sent to the principal's office. And so because they suspect that they may be on some kind of drugs, they decide to strip search them. Okay. And so, going back to the Act of 1680, right? And it is hereby further enacted by the authority aforesaid that if any Negro or other slave shall absent himself from his master's service and lie hid and lurking in obscure places, committing injuries to the inhabitants, and shall resist any person or persons that shall by any lawful authority be employed to apprehend and take the said Negro, that then, in case of such resistance, it shall be lawful for such person or persons to kill the said Negro or slave, so lying out and resisting, and that this law be once every month, every 6 months, published at the respective county courts and parish churches within this colony. So, laws that continue to condition white people, as Theodore Allen states, to degrade Black people, to murder Black people, to just enact relentless, endless, psychotic terror that is premised and facilitated by and through the legal context. How does that get turned off in a culture ever? And I suspect, no, I know that this is what we're dealing with. We have a culture that was built on violence. It was erected on the foundational components, if you will, of violence enacted against indigenous people, enacted against Black people in very severe ways. And we want to downplay the remnants of that and the effects of it. And there's no downplaying it, right? I go to this law just to share one other example where the language is further clarified. It says, and if any slave resist his master or owner or other person, or I'm sorry, let me go start over. And if any slave resist his master or owner or other person by his or her order correcting such slave, and shall happen to be killed in such correction, it shall not be accounted felony, but the master, owner, and every such other person so giving correction shall be free and acquit of all punishment and accusation for the same, as if such accident had never happened. And also, this is the transition from Christianity or using Christian and not specifying which Christians are being targeted, if you will. This is kind of the beginning of that in terms of the next portion of this law. The next portion says, and also if any Negro, mulatto, or Indian, bond or free, shall at any time lift his or her hand in opposition against any Christian not being Negro, mulatto, or Indian, he or she so offending shall for every such offense proved by the oath of the party receive on his or her bare back 30 lashes well laid on, cognizable by a justice of the peace for that county wherein such offense shall be committed. So they're not concerned about Black people or mulatto or Indian people fighting Christian people at all. Because what this law constitutes is that Negroes and mulattoes and Indians can fight with each other. They can fight Black Christians, fight mulatto Christians, fight Indian Christians. They just can't lift their hand against any white Christians. That's what this law basically says. Okay. And so there's a culture of total fear built out of terror. One point I'll make, as Africans and Native Americans begin to be converted to Christianity, which is taking place between really the early 17th century and the late 17th century. So by the 1700s, the conversions were in place in ways where Christianity was more widespread amongst indigenous communities and amongst the population of Africans and or African Americans that were existing throughout the colonies at that during that period. It says, as that happened, such a simple distinction between Christian and non-Christian was no longer useful, at least as a legal and political difference. In addition, because Europeans, Native Americans, and Africans often worked and lived together in similar circumstances of servitude and resisted and rebelled together against the way they were treated, the landowning class began to implement policies to separate European workers from African and Native American workers. Even in this early colonial period, racism was used to divide workers and make it easier for those in power to control working conditions. Drawing on already established popular classifications, whiteness, now separate, somewhat separate from Christianity, was delineated more clearly as a legal category in the United States in the 17th century, and the concept of lifelong servitude was introduced from the West Indies and distinguished from various forms of shorter term servitude. In response to Bacon's Rebellion and other uprisings, the ruling class, especially in the populous and dominant territory of Virginia, began to establish a clear racial hierarchy in the 1660s and 70s. By the 1730s, racial divisions were firmly in place legally and socially. Most Blacks were enslaved, and even free Blacks had lost the right to vote, the right to bear arms, and the right to bear witness. Blacks were also barred from participating in many trades during this period. Meanwhile, whites gained the right to corn, money, a gun, clothing, 50 acres of land at the end of indentureship. In other words, poor whites gained legal, political, emotional, social, and financial status that was directly related to the concomitant degradation of Indians and Negroes. Did you know? That concludes this portion. Thank you so much for watching, and I look forward to coming back to share more at another time.